This podcast is brought to you by Bloomberg Law. For more information about our professional services for the legal industry, please call 212-617-6569.
This is Bloomberg Law's Intellectual Property Review. I'm Josh Block. A departure from IP today to discuss broadcast regulations, specifically last week's oral arguments at the Supreme Court in FCC v. Fox. The afternoon broadcast of George Carlin's 7 Dirty Words in 1973 led to a Supreme Court decision allowing the FCC to ban indecent material from broadcast media from 6 a.m. to 10 p.m. In a time before the internet, before cable TV, before satellite, the rationale for allowing regulation was broadcast media's uniquely pervasive presence in the lives of all Americans. Today, roughly 90% of households receive broadcast content through cable or satellite. So is it time to change the rules for broadcasters and either require the FCC to rewrite their indecency regulations or perhaps even overturn the George Carlin 7 Dirty Words case altogether? I'm joined by Tom Taylor, an editor of Bloomberg BNA's U.S. Law Week, who attended the hearing. The New York Times account said it was a rollicking argument, equal parts cultural criticism and First Amendment doctrine. Was it as lively as that account suggests?
Well, Josh, it was a fantastic argument. It was, a lot more accessible than some of the kind of deeper legal issues that you typically see in Supreme Court arguments. I don't know if I'd go with rollicking, seeing as they made it through, a full hour of argument without actually uttering any obscenities or any profanity.
What got us to this point? Give us the background of the cases. They involved Nicole Richie and Cher and NYPD Blue.
It all traces back to the very famous George Carlin monologue, Filthy Words, where he basically goes over the 7 or so words that you never, ever say on television. And that was broadcast over the radio in 1975, and the FCC stepped in and said that it was a violation of federal law as broadcasting indecent content. Well, then things kind of stayed static until we get to Nicole Richie and Cher, both at the Billboard Music Awards in 2002 and 2003. And at the time, Cher was responding to some criticism about the longevity of her career, and she used the F word in responding to those critics, kind of out of nowhere. And same thing with Nicole Richie. She was at the time on the show The Simple Life, made a quip about getting cow feces out of a Prada purse and how difficult that can be, contrary to the name The Simple Life of the show. So the FCC received some complaints about that. They basically said, we're going to treat this as indecent content and let the networks know that. Now, interestingly enough, they weren't actually fined because the FCC did recognize that this was a change in policy. So it was basically, came across as a warning. But ABC, on the other hand, those broadcasts were on Fox, was in fact fined in 2000 after a 2003 episode of NYPD Blue called Nude Awakening, and the episode showed a female from behind in nude from the waist down, female buttocks.
How does a broadcaster know if something is indecent? Fox didn't know and wouldn't have known, so it was a warning. But going forward, they're on notice that something like that is indecent, I assume. How do they know? What's the rule?
That really is the kind of major question that they were debating at argument. After the Supreme Court actually sided with the FCC once before on a kind of administrative issue, basically saying that their policy was up to snuff under administrative law and kind of a little more boring. The Second Circuit actually shot down the policy as constitutionally vague, saying exactly that broadcasters don't know where the line is. And that was a major point of the argument. And basically what it boiled down to was indecency speaks to sexual or excretory organs or activities. And then it goes on to say that, any use or any description of those organs or activities has to be patently offensive. And they basically have laid out that means that the material dwells on or repeats at length descriptions of of those organs or activities, whether the material panders or is used to titillate an audience, how explicit or graphic in nature these things are. But these are all very broad terms, and basically what the government was arguing was that it's a context-based rule, so that the FCC has to have some leeway in determining what is indecent. Otherwise, you basically get stuck with a list of words or images that you can never say, which, from the government's point of view, is even more of a First Amendment problem because it grants the government absolutely no flexibility in terms of letting things that have a very high artistic value or, are socially redeeming in some way that, Cher and Nicole Richie aren't. And the two big examples that came up on several occasions were the broadcasts on network TV of both Saving Private Ryan, which used a good amount of profanity, and Schindler's List, which actually had some nudity in it as part of the depiction of the concentration camps in that movie.
Right, and Justice Kagan remarked that only Steven Spielberg can show nudity and use dirty words.
Yeah, she got a great response from the crowd. Oftentimes, audience members, they let in a good amount of the public. And oftentimes, you can watch them kind of fall asleep or or get lost or not really paying attention. But that was a line that really brought everybody back in. And basically, yes, Kagan said, under the FCC's current rule, only Steven Spielberg can get away with dirty words or nudity. So, that may be the case. I guess that remains to be seen.
Right, the Spielberg test as we go forward.
Right, exactly.
What is the court being asked to decide ultimately? What do the broadcasters want to have happen?
The broadcasters want the court to revisit a decision that came out of the George Carlin monologue in 1978, the Pacifica case. There, the Supreme Court took the view that broadcast TV and radio is more so than other forms of media and media speech, highly invasive. It comes in, it's broadcast into the house, into people's homes, without their permission, without any active participation on the average citizen's part. Of course, you have to set up a TV, put the rabbit ears up, all that kind of good stuff. But generally speaking, the signals are crossing into the home, and therefore it's okay to regulate it on First Amendment grounds, on freedom of speech grounds, because in order to protect children and other reasonings that the government relied on in that case, the networks would like to see that case and that decision be overturned and go away in light of what they really harked on and really pointed to as technological changes since then. Now more and more people are not using broadcast TV or not paying attention to broadcast TV. They're cable subscribers. They're satellite TV subscribers. There are other technological fixes like the V-chip that, if you're worried about protecting children, can serve as a intermediary and help parents to monitor what their children are watching, more efficiently. So the networks would really like to see that case have the court take a second look at that decision and basically say that it's no longer worth it for the government to regulate broadcast TV and to a lesser extent, I guess, radio, although that wasn't really at issue in this case.
One thing that I find interesting here is that these incidents, the Cher and Nicole Richie and NYPD Blue, they all happened close to 10 years ago now, and the argument and rationale shifts significantly over time. Cable and internet penetration is much greater now than it was even when those incidents happened. So Justice Roberts questioned that significance, saying that the argument cuts both ways. What was he saying?
In my opinion, kind of tipped his hand a little bit here. He pointed out to Carter Phillips, who was arguing on behalf of Fox and was really handling the First Amendment side of the argument as opposed to the vagueness side of the argument. And he said, what we really want, and he said we, and then stopped himself and kind of backtracked a little bit and said, we're just, people just want a safe haven, a couple of channels that they can rely on to set their kids down in front of and not worry about F-bombs and S-bombs and nudity, and that the broadcast networks provide that safe haven. And the argument that they're going away or there are more and more cable subscribers, it does cut both ways, because if you've got 800 if you've got 800 channels on cable and only 2 or 3 or 4 broadcast stations, that means that safe haven is getting smaller. So it's more important that the government step in to protect that safe haven when it's getting less and less and less penetrating to in the public sphere. Obviously the networks tried to take that the other direction. There's only a couple of these channels left. Most of what everybody is watching is cable or satellite, and they're not getting it this way. So why do we have these, for lack of a better word, archaic rules about what you can show on network TV when really nobody's paying attention anymore?
And that goes to an argument that some people make that, perhaps our broadcast media would have better content if they didn't have chains around them, or if they weren't held back. Was that point made?
Basically, it was a market, a free market argument, that even without government regulation, there would be channels and programming available that would be of high quality for children. You look at things like Nickelodeon on cable and things of that nature that are inherently geared towards children, and that's because the market demands them. So I think that the networks at one point definitely came back and said, the government's role here is unnecessary because the market will provide this safe haven. I'm not entirely sure that they were saying that their content would be greatly enhanced by lifting these regulations, but I think they did try to argue that by even the FCC saying that Saving Private Ryan and Schindler's List were okay, that there are moments and occasions when slipping past these indecency rules or going beyond them is seemingly a betterment to TV programming.
Justice Alito said that broadcast TV is living on borrowed time. Why not let it die a natural death? Mm-hmm. I think that's an argument for the status quo.
Yeah, the Supreme Court generally does not like to overrule itself. It's governed by the doctrine of stare decisis, and if they can avoid overruling a prior decision of the court, they will. So I think what Justice Alito was getting at there was, this isn't going to be an issue for that much longer. I think the number that was thrown around in a couple of the briefs, and also that Justice Kagan brought up at oral argument, was that 10% of households are now getting their TV via broadcast over the airwaves and nothing else. And that that number is that number is steadily going down, and it's going to continue to go down. So why do you want us to take this drastic constitutional step when we could just kind of let this peter out on its own?
It's a little funny because it seems to acknowledge that perhaps broadcasters could compete better if they didn't have the restrictions, and the notion that there might actually be a natural death of broadcast media. How did the attorneys respond?
When Justice Alito mentioned the dying a natural death line, Carter Phillips, who was arguing for Fox, quipped back at him that my clients would be surprised to hear you say that, or my clients would be dismayed to hear you say that, something along those lines. And the truth of the matter is that was a big point of the government's. Basically, they were saying, these broadcasters get this spectrum from the government. They get it for free. And the idea that we can't step in and regulate, and give a modicum of decency, as I think Justice Scalia at one point put it, to over-the-air broadcasts, it's a little bit of looking a gift horse in the mouth. They broadcasters now get preferential treatment from cable providers by kind of having to put their channels in prime positions. They get this spectrum for free. They're licensed by the government, and to say that the government can't deal with these speech issues is, they're getting something of value, and that gives the government a little bit of a freer hand.
Seth Waxman, one of the attorneys arguing that the FCC's indecency standards are vague, came up with a novel and amusing way to make his point. What did he do?
Yeah, he was bringing up a point about the last Olympics, and that there were a couple statues in the opening ceremonies that displayed bare breasts and buttocks, as he himself put it. And then he pointed out to the justices some of the sculpture and artwork in the Supreme Court itself. And there's a frieze that circles the entire courtroom that depicts various lawbringers, Draco and the Ten Commandments and things of that nature. And there are some bare buttocks in that frieze. And Seth Waxman made a point of saying, if ABC doesn't know whether or not they can broadcast the Olympic opening ceremonies because of a statue, would they have to question whether or not they could broadcast Supreme Court oral arguments because some of the statues here? And he definitely got a handful of the justices up and taking a look at the friezes, and they were clearly, looking around the room. At which point, Seth Waxman jumped on the opportunity and, pointed to one of them in particular to his right and said, "Over here, Justice Scalia," and that got a big laugh from the courtroom and kind of lightened the mood a little bit, and actually resulted in something that I don't know that anybody has ever seen in the midst of an argument, but it really looked like Justice Scalia blushed a little bit.
Was that off the cuff? Was it planned? I mean, it sounds like it was planned.
I think he certainly knew that he was going to talk about the artwork in the courtroom. It's fairly well known that some of that artwork exists. I don't know if he had Justice Scalia targeted from the beginning to kind of be take the brunt of the good humor, but I think he definitely wanted to point that out and knew that would be a good example that would kind of strike extremely close to home for the justices.
The broadcast media is no longer the uniquely pervasive presence in the lives of Americans that it once was. If that's the rationale they've been hanging indecency regulations on in the past, did you get a notion that they're going to hang it on something else now?
I think that the court is hesitant to get into the First Amendment implications here. It doesn't seem to me like it's going to be entirely necessary for them to make that leap when they've got a vagueness issue that, kind of like how Roberts tipped his hand on the safe haven thing. Justice Kagan kind of did the same thing when she was talking about vagueness, and to Solicitor General Verrilli's dismay, she basically said, ABC feels like this is vague. ABC is more or less right. She kind of said there's definitely some vagueness here, to which, of course, the government took great issue. But, it seems to me like they may not want to bobble and juggle with the First Amendment issues when there's kind of an easy out for the justices with the vagueness issue, and could just basically ask the FCC to clean up its standard, give it a little more clarity, and leave it at that.
One notion that seemed to be floated by justices in the questioning was that without indecency regulations, broadcast media would turn into a place where it would just be full of nudity and dirty words. Did you get the notion that was a real concern of the justices? And the reason I say it is because cable doesn't work that way, and they don't have indecency regulations, and broadcast networks don't have the regulations after 10 p.m. So it seems like an odd argument to me.
As for the way that things work after 10 p.m. or the way that things work on cable, certainly a couple of the justices particularly Justice Scalia, really kind of seemed to believe that without some kind of regulation, it would turn into the Wild West, and that it would be, a much different environment or broadcast climate if these rules weren't there. That being said, Justice Kennedy also chimed in and kind of made the notion that not even the broadcasters but the interviewees, the people who were giving these speeches at music award shows and that were being interviewed, if they knew that the rules were no longer there, that they would take it upon themselves to be as outrageous as possible. And I think he mentioned a group which it seemed to get his dander up a little bit in that wannabe celebrities, I think is exactly what he said, would be out just to be as outrageous as possible and to take these opportunities to say something that they knew would cause shockwaves.
Justice Sotomayor did not participate. Do you know why?
She was, this case comes out of the Second Circuit, and of course, before she was elevated to the court, she was a member of the Second Circuit Court of Appeals.
You need 5 of 8 justices to change anything here, and from everything that we've just talked about, it doesn't sound like the votes are there. It sounded like, from the questioning that you got from Alito and Scalia and Roberts, it seems like you kind of have a sense of where they're going. Probably Thomas isn't far behind. That's 4 right there, so you don't have the 5th.
The First Amendment issue seems, the much further reach for the networks. Now, the vagueness issue, I think there's a decent chance that they may just either because a 4-4 split in this case upholds the Second Circuit decision, and the Second Circuit said that the rule that's in place now is unconstitutionally vague. So they need 4 votes on the vagueness issue. And like I said, Justice Kagan seemed inclined, Justice Ginsburg the same way. And, Thomas is an interesting case. He does not usually speak in oral argument, so it's hard to get a sense there. But at the same time, you can imagine him kind of coming down with Scalia and Roberts and Kennedy on the First Amendment issue of wanting to protect children, needing a safe haven, that type of thing. But at the same time, he also is a bit skeptical when it comes to major government involvement in people's lives and in things like free speech, and in particularly where the government is regulating in a way that does not give whether it be broadcasters, business interests, anybody, a decent amount of clarity. I think he may find that problematic. So, while I don't know exactly where everything is going to come down, I would think that the vagueness issue is really the one to watch here.
That's Tom Taylor of Bloomberg BNA's U.S. Law Week. You can find our recent podcast at BloombergLaw.com and on the Bloomberg Law YouTube channel. Thanks for listening.
Copyright 2011 Bloomberg Finance LP, all rights reserved. The views expressed herein are those of the speakers and not of Bloomberg Finance LP. These discussions are for informational purposes only and should not be construed as legal advice, which has to be addressed to particular facts and circumstances involved in any given situation. Bloomberg Finance LP and its affiliated entities do not take responsibility for the content contained herein and do not make any representation or warranty as to its completeness or accuracy.